Imagine lending your best friend $20,000 to help him start a business. He promises to pay you back within a year. 12 months later, he refuses and insists the money was a gift. Who is telling the truth? Today, we examine an original fictional courtroom case that explores friendship, trust, and the importance of written agreements. For over 15 years, Michael and Daniel had been inseparable. They grew up together, celebrated milestones together, and trusted each other completely. When Daniel dreamed of opening a coffee shop, he couldn't secure a bank loan. He turned to Michael for help. Michael transferred $20,000 to Daniel's account. According to Michael, Daniel promised to repay the money within 1 year. Daniel says something very different. He claims Michael gave him the money as a gift because they were lifelong friends. For months, everything seemed normal. Then the deadline passed. No payment arrived. Michael repeatedly asked about repayment. Each time, Daniel delayed. "I just need another month. The business is struggling. I'll pay you soon." Eventually, Daniel stopped responding altogether. Michael decided he had no choice but to file a lawsuit. In court, Michael stated, "I believed in my friend. I wasn't investing in his business. I was lending him money." Daniel replied, "There was never a loan. Friends help friends. He never asked me to sign a contract." Without a written contract, who should the court believe? Michael presented several text messages. One message from Daniel read, "Thanks again for the loan. I'll pay every dollar back." Daniel argued that he had used the word loan casually. Then another message appeared. "I know I still owe you. Business is slow. Please give me more time." The courtroom fell silent. Next came bank records showing the $20,000 transfer. Finally, Michael produced an email in which Daniel had proposed a repayment schedule. Daniel admitted sending the email, but claimed he only wanted to keep the peace. The judge considered all the evidence together. The court explained that while written contracts are helpful, they are not always required to prove a loan. The text messages, bank transfer, and repayment email all pointed to the same conclusion. Both parties understood that the money was intended to be repaid. Calling it a gift after repeated promises to repay was inconsistent with the available evidence. The court ruled in Michael's favor. Daniel was ordered to repay the $20,000 according to a court-approved payment schedule. The judge reminded everyone that even close friendships should involve clear agreements when significant amounts of money are involved. Trust is valuable, but documentation can prevent costly disputes. What would you have decided? Should Michael have insisted on a formal written contract before transferring the money? Or was the evidence enough to prove it was a loan? Share your opinion in the comments and subscribe for more original courtroom stories and legal discussions.